A federal judge has ruled in favor of the University of North Carolina at Chapel Hill in a lawsuit challenging the university's admissions policy. Judge Loretta Biggs rejected arguments that UNC had violated both the Constitution and federal civil rights law by using racial preferences in admissions. Joining us with reaction to the decision is Kenny Hsu. He is president of the group Color Us United and author of the book, An Inconvenient Minority. Kenny, thanks for joining us.
Thank you for having me again, Mitch.
And one of the reasons we wanted to chat with you, Kenny, is that your book, An Inconvenient Minority, talks about a similar situation, and that is lawsuits challenging the admissions policies in the Ivy League. Based on what you've seen in covering those cases very closely, especially what's happening in Harvard, what was your reaction to what you saw in this ruling from the case involving UNC?
Similar. It's a very similar case. The only difference is that Harvard is technically a private university, but of course they take $500 million in government funds, which subjects them to Title VII of the Civil Rights Act. But UNC is a fully 100% public university, and the district court's ruling is not surprising. The district court has to stay compliant with Supreme Court original precedent saying you can use race in admissions under certain conditions. Of course, we want the Students for Fair Admissions, I'm sure, is planning on appealing it directly to the Supreme Court where they're not bound by that precedent. So it doesn't surprise me. There are real harms of the racial preferences is the larger issue at hand. When you use race in admissions, you are actually discriminating. You are discriminating against higher qualified, well-qualified Asian Americans and whites to make room for lower qualified Blacks and Hispanics, at least in this case. And that is something that is unacceptable from the perspective of admitting the most qualified candidate, of treating a person according to individual, treating a person according to the content of their character. And so that's what we're fighting for here, and that's what I hope to continue fighting for.
I'm going to throw a couple of the lines from Judge Biggs' decision at you and just get your reaction as someone who has watched this from the perspective of other similar cases. Judge Biggs, talking about UNC's policy, says it's actually a highly individualized, holistic admissions program, and that no student was admitted simply because of their race. My guess is there's been similar arguments when these have been challenged in other places that race isn't the only factor, so the programs are constitutional.
Sure. If it's so highly individualized, if it's so holistic, then why even have race as a factor, right? Why even spend tens of millions of dollars, as UNC did and Harvard did as well, trying to defend race in admissions? What are you trying to hide here? If race is just one small factor out of many small factors, or if race is just used as a tiebreaker, you should feel no need to defend this small parcel in your admissions process. But we know this is not true. In Harvard's admissions documents that were revealed, it has become clear that Harvard assigns a penalty to Asian Americans just for being Asian. Asian has to score 450 points higher on the SAT to have the same chance of admission as a Black person, and 150 points higher than to have the same chance of admission as a white person. The evidence is so clear that race is not just a tie-breaking factor, but a highly, hugely significant factor in admissions, that it just renders the argument of this pretty silly, in my opinion.
Moving forward, you mentioned that that this ruling is not surprising given the Supreme Court precedent, but one of the goals is to change what the Supreme Court says about this going forward. From your vantage point, as someone who's been looking into these issues, from someone who works with a group now called Color Us United that deals with these issues, what do you hope the Supreme Court says if and when this case and or the Harvard case get back in front of them?
Certainly, I want the Supreme Court to overturn the use of race in admissions. There's no point anymore. Their race is no longer a proxy for things like wealth, class, and status. You have so many rich Black applicants in this country today, rich Hispanic applicants in this country today, and in fact, 71% of Harvard's own Black applicant class is upper middle class or higher. So it's not a policy anymore that actually redresses for anything in any sort of accurate or way, even from the liberal standpoint of view. So hopefully, and by the way, in Grutter versus Bollinger, the first case that where people said where the justices argued you could use race in admissions following Bakke, this Justice Sandra Day O'Connor said, hopefully the use of race in admissions will be obsolete in 25 years. And that was in 2003. So guess what? It is nearly 20 years later. We should be phasing out the use of race in admissions. There should be no excuse. This is time.
One of the other things that Judge Biggs mentioned in her ruling was she said that even 70 years after UNC admitted its first Black students, minority students are still being confronted with racial epithets and feeling isolated, ostracized, stereotyped, and viewed as tokens. That no one, I think, would want to see something like that. Are there ways for a university like UNC, Harvard, or other schools to address these problems that don't involve using race preferences in admissions?
So this is the issue. This is another issue I have with her ruling. Facing hate or incidents of bias incidents in your college should be a reason why you should have an entirely race-blind admissions process, why you shouldn't care about race, why you should phase out the category, so to speak, because using race admissions process from the moment the person steps, even before the person steps into your college, just the very fact you use race in the admissions process now means that people are being trained to think of themselves in a racialized way. In fact, one highly accurate online medical school admissions evaluator only asks for 3 factors if you want to get into medical school. That is your GPA from college, your MCAT score, your medical admissions test score, and your race. It's there, and they with those 3 factors alone, you can predict with alarming accuracy, people getting into these colleges. So by having a racial preferences system, you are only internalizing race even more into the paradigm. Instead of taking race out of the equation, you're continuing to sponsor racial resentment on campus.
We've already alluded to the fact that this case, if the Supreme Court's willing to take it, could go back to the Supreme Court, and you could get a new precedent that would shift the situation. How confident are you that the Supreme Court, now nearly 20 years after the last ruling, would be inclined to look at things in a different way?
I think that if the strongest chance, I think, is now. I think the Harvard case and the UNC case, when they come to the Supreme Court, and they might both be argued in the Supreme Court next year. The Harvard case is already at the foot of the Supreme Court this year. I think this is as good of a chance as any. We have now even John Roberts, who has kind of flip-flopped in the past, has expressed strong opposition to racial preferences in admissions. He has said as much. He said the best way to stop discriminating on the basis of race is to stop discriminating on the basis of race. So I think that this is a unique opportunity. I think we need to take it.
Kenny Xu is the president of a group called Color Us United and author of a book called An Inconvenient Minority. It doesn't deal with the UNC case, but deals with similar case at Harvard dealing with racial preferences in student admissions. Kenny, thanks so much for joining us.
Thank you.